Call the case of the people versus Daniel Mcoo. State your name.
Daniel Mcoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on its face. That were going
to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that.
All right, before we jump headfirst into Daniel's legal circus, let's set the stage. What you're about to watch is a masterclass in courtroom overconfidence, colliding with legal reality. Daniel walks in like he's been binge-watching sovereign citizen TikToks for 3 nights straight and thinks he's cracked the code to the entire judicial system. He starts firing off motions, referencing statutes, quoting definitions, and trying out logic, a judge who's been doing this longer than Daniel's been Googling how to beat my case.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lomby has let me know that all paper discovery has been sent to Mr. Mcoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Mcoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Mcoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him?
I expect that you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Mcoo, starting in case ending in 0979, Mcoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, excuse me, including and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a 3rd offense notice, which transforms this into a felony charge. It's punishable by up to 500.
This right here is a classic moment where sovereign citizen-style defendants hit a wall. Daniel genuinely believes his interpretation of the statute automatically invalidates the charge. But courts don't dismiss felonies based on broad claims or defendant interpretation. They need legal precedent, procedural timing, and evidence. The judge's quick denial signals something important. Daniel is playing checkers while the court is playing chess. She reminds him that the preliminary examination is where these arguments belong. This is a subtle but crucial detail many defendants misunderstand. Court isn't a debate club. Arguments must occur at the right time, in the right format, with legal grounding. Daniel hasn't done that, which is why the judge shuts the door instantly.
Mr. Mcoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. Mcoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torsia Fisa, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Good.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over I think 390 some days since the warrant was requested. And this triggers due process violations under U.S. versus Lavasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide or pass the or provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the.
Notice the prosecutor's tone here. Measured, calm, strategic. While Daniel is trying to spark legal fireworks, the prosecutor is simply pushing things forward. When the state says they're ready for a preliminary examination, that's not a small thing. It means they're confident they can meet the burden of proof to bind Daniel over for trial. Meanwhile, Daniel challenges every detail, even asking the prosecutor to prove the suspended license conditions, notification, operation, road location, everything. That sounds bold, but prosecutors deal with this daily. They know exactly what records to pull. And if the state is requesting proceed, that's a sign they already have what they need. Daniel's aggressive pushback may make good drama, but legally, it doesn't shake the state at all.
A response from the people regarding his bond.
The people would ask the bond to continue, and he also at the bench warrant failed to appear before the judge's place. So
Yes.
that warrant would also hold up with respect to the other. I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the public defender's office, I will make sure that the digital discovery that I referenced is served on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation.
Here's where the contradiction really starts showing. Daniel says he wants a speedy trial, but also admits he didn't know what hearing he was attending and wasn't prepared with or without video evidence. That's a big problem. Speedy trial rights don't mean rush the process before I understand anything. They mean the state can't cause unreasonable delays. Meanwhile, the judge is trying to give Daniel the chance to review critical evidence, the very thing he needs for a fair defense. When defendants insist on speed over readiness, it usually hurts them, not the prosecution. The judge is essentially saying, don't sabotage your own case. But Daniel is caught between wanting control and not understanding the process, which creates this chaotic tension you keep seeing on
A civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those do not interrupt me. including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware that such note or such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case, and until I hear otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, deny.
This is a major moment most defendants underestimate. When the judge reads the charges, she's not just giving information. She's reminding the defendant of the stakes. Daniel isn't facing a simple traffic violation. He's staring down felonies: fleeing police, DUI third offense, escape from custody, driving while revoked, refusal to obey an officer. The list is long and serious. Felony DUI alone carries up to 5 years and thousands in fines. This isn't the time to play amateur attorney. The judge is subtly nudging him toward representation by laying out the harsh penalties. It's her way of saying, this isn't a YouTube debate. These are life-changing consequences. It's a powerful reality check, one Daniel desperately needs but hasn't fully absorbed.
Let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Ms. Gay, take her testimony as to the basis for the PPO. I will hear in a response from Ms. Campbell why I should terminate the PPO, and then I can make a ruling. So, Ms. Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Ms. Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
They threw eggs at my home.
Was
and
it
then
during that same big brouhaha on the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay.
And
All right.
then
And who were the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling, I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter. They were throwing eggs. And then the next day, she was on the neighbors on their porch, just constantly yelling at my house. I've never had a conversation with her yelling.
This part reveals the judge's patience and her limits. She's dealt with Daniel before. Clearly, she repeatedly warns him that representing himself is dangerous, especially in felony cases involving procedure-heavy issues like DUI third offense and fleeing police. When she asks him a yes or no question about wanting counsel, Daniel tries to reinvent the answer by saying he wants legal assistance, which isn't a valid category. The judge finally interprets it correctly because she knows what's at stake and isn't willing to let him self-destruct. Court-appointed counsel isn't a downgrade, it's protection. Daniel's misunderstanding of legal terminology keeps creating friction, and the judge is trying to stabilize the situation before it spirals.
As soon as they sent them to me with her ranting and raving about how she was going to kill me, I went right downtown to the police department and I sent it to them. That's two of her telling me she's going to threaten me. I got one actually with her video, and I have her ranting in the backyard, just yelling and screaming and scaring my grandkids, telling them that how she's going to hurt me. And it just went on and on. And I have witnesses, guests over, like, oh my God, you have to listen to that. I'm like, yes. She keeps
Okay.
threatening
Well,
me.
let me see what Ms. Campbell has to say about it. Ms. Campbell, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Ms. Campbell, you
Well-
say in your response here, you think there should be a termination. It does say you're off probation. What were you on probation for?
I was on probation for the incident with her daughter and stuff, and ever since I've been off probation, she's been harassing me and my I have an 18-year-old daughter, and so she has a daughter that's my age or whatever, and stuff. So basically, ever since that incident, she's now that her daughter, so she basically got her daughter, her grandkids, and like her nieces and them making up stuff. I never once threw eggs at her house. I never said nothing to her. She came to my house, her and her daughter and her grandkids. I
Hang on,
never
you gotta let her testify, Ms. Gay, and then I'll give you a chance to respond.
now since she came to my house, that was May 31st. I have two incidents from this year. May 31st, which I put in the police reports in February 9th.
Daniel now argues that the charges are facially invalid, cites multiple cases, and tries to use constitutional arguments to request a personal recognizance bond. But here's the critical issue. Judges don't modify bond simply because a defendant claims their charges violate constitutional amendments. Bond decisions are based on risk, flight risk, danger, prior failures to appear. And remember, the state already implied Daniel previously failed to appear. That alone can stop a PR bond cold. His attempt to lean on legal jargon without tying the arguments to factual findings or procedural history weakens his position. This moment shows the gap between quoting cases and successfully applying them in a court.
She never called the police. If I threw eggs at her house, why didn't she call the police? She came over here with a mob of people, her whole generation and stuff. It's only me and my daughter and my 9-year-old daughter. You look, I have a 9-year-old daughter and an 18-year-old. Today, my daughter turned 19, so they're 10 years apart. That's not true. I never said I left in an ambulance. They assaulted me, her and her kids. And she has the background. You can look on the camera. She drove her car over to my house. I never once went over to her house. She
Well,
came
that
over
you're
to.
talking about the big fight that happened in the street on Zeno Street
It didn't have. It happened on Hall Street, not
or Hall
Zeno.
Street? Okay.
Yes, she came over. Her family came over to
Yeah,
my
I
house.
don't want to reissue the fight because she's saying, well, since that fight, this
Nothing never
thing
happened.
escalated.
Since after that, yes, she's been calling CPS. They've been calling the city. They've been calling, making now she's trying to do a PP and fearing her life or whatever. Lady, I've been staying here for 3 years. I never, come on now. I never said nothing to her. I never, some eggs. It,
And you're not yelling at her from the back porch where she could
no,
hear from her
no,
house.
I am not. You could ask the judge. You could get active and come to the neighborhood. I've been staying here. They saying that me and my kids now she's going around saying my 9-year-old daughter with a taser. They brought the taser to the fight, and then my 9-year-old daughter
Yeah,
picked it
well, the
up.
taser's not part of this PPO,
I
so
know,
I'm gonna
but this
leave
is
that thing
but it
alone.
was led up to is what leading up
Yeah,
to this
I get
mess
it.
or whatever and stuff.
Let,
I
let me
never
bounce
said
back to
nothing.
Miss Gay and ask her about that. Miss Gay, have you been making CPS calls about Miss Campbell's parenting?
I have.
And there you have it. Daniel's entire attempt to outmaneuver court ends exactly where it was always headed. The judge denies dismissals, rejects premature constitutional claims, sets preliminary examinations, and ensures Daniel has legal counsel moving forward. This hearing shows a critical truth. Confidence doesn't win cases. Procedure does. Daniel's arguments weren't necessarily malicious, but they were unfocused, mistimed, and unsupported by the standards required in criminal proceedings. The judge maintained control, preserved Daniel's rights, and kept the process on track despite the chaos.